Welcome to Devin Boyce and Plimpton. I'm a partner here and I co-chair the firm's global cybersecurity and data privacy practice. It's very nice to have you with us. Let me start with some quick introductions, and I'll start on the screen. Edgar, I hope you can hear us. Okay.
Yes, very well.
Okay, great.
Good to see you.
Nice to see you, and thank you for being with us long distance. Edgar D'Andrea is PwC's lead partner of cybersecurity and privacy in Brazil, based in São Paulo. Edgar has 35 years of professional experience in complex consulting and auditing service in IT, cybersecurity, and privacy. Up here on the dais with me, to my immediate right, is Marcelo Laxman, who is head of the cybersecurity and data privacy practice group and a partner in the M&A team at Tosini in São Paulo. And an old friend. This is our third cybersecurity and privacy panel in the past month or so. And to Marcelo's right is José de Sá, who is the Information Security Officer for Banco do Brasil for the U.S. operations, and has been in that role since 2010. So our topic for today is data privacy and cybersecurity in Brazil, what's next? And what we thought we would do to start you out is give you a little bit of global context. The main theme here is that corporate networks don't have geographical borders. Corporate networks tend to be connected. You may be doing business in Brazil, but if you have affiliates or subsidiaries outside of Brazil, chances are, or vice versa, chances are your networks are connected. But the law is trying to erect borders where technology does not really recognize them. So let's take a quick look at what we mean by that. The best news I can give you all this morning is almost no PowerPoint, only one slide. Okay? And after that, it'll just be conversation. Okay? But we wanted to show you a little bit of what's happening. And the main point here is that there is just an incredible rate of change. Everywhere you look, there is more law, new law, more rigorous law on cybersecurity and data privacy. And just to give you a few examples, the state of California, many of you probably know, just passed a new privacy and security law called the CCPA, California Consumer Privacy Act, and it is the most rigorous privacy law ever passed in the United States. And although it was passed only by one state, it really has national effect because it applies to, and global effect because it applies to any company that is doing business with people in the state of California. The state of New York, where we are today, just last year passed a cybersecurity regulation, which Jose knows very well because he has to live with it. And it was a regulation passed by our Department of Financial Services, and it applies to any company that holds a license from the DFS in New York. That means essentially every major bank and insurance company in the state and the country and even in the world, because if you were licensed to do business in New York, regardless of where you're located, you have to comply with the regulation. Moving around the map a little bit, now highlighting Brazil, two big developments, which will be our main topics for today, a new cybersecurity regulation from the central bank, and a new statute called the LGPD, which applies more broadly to data privacy in all sectors of the economy. And just to show you, the US and Brazil are not alone here. Canada just passed, just enacted mandatory data breach notification, just took effect within the past couple of weeks. A few other examples. Europe, of course, has the GDPR, and the new Brazil law, the LGPD, is very, very similar to the GDPR. And one of the main principles being that they both claim to apply no matter where you are. If you're touching people in the European Union, you are covered by the GDPR, even if you're based in America, based in Brazil, based anywhere. A couple of other examples, Japan and China. Japan just reached basically a trade deal with the EU on personal data. That Japan and the EU now recognize each other as providing an adequate level of data privacy and data protection, and that means that data can move back and forth across national borders freely. It's like a free trade zone in personal data between the EU and Japan, so that's a big development. China has been rolling out a whole series of new privacy and security laws, including requirements for what's called data localization. It's a requirement that data actually must physically stay in China and cannot cross national borders, cannot leave China except in limited circumstances and with rights of inspection by the Chinese government. So that can look into your data as it crosses the border the same way they could look into your suitcase if you were leaving the airport in Beijing. A couple of other examples we've got, I'll just be quick here. Thailand and India both have new data privacy laws about to be enacted. India now has data localization. Australia now has data breach notification. These are just a few examples. We could spend the entire hour doing nothing but filling this map, okay? Because there are so many other countries that have enacted new privacy and security laws. But the main message here is that Brazil is not alone, the US is not alone, and one of the main problems a company faces these days is how to run a global network which doesn't, as I said before, technology doesn't respect borders, in a world where every country wants to make its own rules. And the rules don't always connect to each other, they may conflict, so it's a big challenge. With that, I'm going to ask Marcella to start us off and talk a little bit about the LGPD and the central bank resolution and just introduce those to the room.
Thank you so much. Good morning, everyone. Thank you for being here, even considering this really bad weather. And so it's a pleasure to be here and to be able to talk to you about this matter, which we've been talking a lot in Brazil recently. I mean, it's as Jeremy said, it's something that is happening all over the world, and Brazil could not be alone and could not, left apart. So what happened was, with the GDPR, there was a concern in Brazil that we would not be in compliance with the rules that most of the world is complying with. So this privacy law that was being discussed for many years in Brazil finally was enacted. It will come to effect in 2020, so February 2020, companies need to be adjusted. But just to give you an idea, we did have privacy rules before. So Brazil has always had a principle of previous consent, express consent, for collection, sharing of data. So this was something that we had according to our constitution, according to our civil code and consumer laws. But with this new law, we now have rules applied specifically to privacy, which we didn't have. So this is the first time we have a law that is only focused on privacy, and it applies to everyone. So things change in Brazil. So we always had privacy rules, and things changed when we had the Marco Civil enacted with internet law. So that was the first step in terms of change in the culture, and internet companies in Brazil already have a good culture of privacy and concern. But now with this new privacy law, all the companies will need to be adjusted. So it applies to online and offline companies, which is a big difference and something that is causing a lot of questioning in Brazil. So basically what we have in the law, it's very similar to GDPR, like Jeremy said. So we kind of copy the GDPR, which is good in a way, which makes, I think, Brazil in accordance with what's happening there. So we will be able to, at some point, have agreements, just maybe like Japan has, if we're, in compliance, if we have same standards that they have in the European community. So I think it's good for the country. And basically, so we still have express consent as one of the reasons and one of the treatments for data. And in fact, it continues to be, I would say, the main requirement for treatment of data. And now we have some new rights which we are not entitled as a user. So now you have the right to have your data, for instance, transferred to another database. So we have portability, which is something new for Brazil. We never had that. We don't know exactly how this is going to work, of course, because you need to comply with commercial confidentiality and there's marketing issues. But this is something that for us certainly will be new and will provide a lot of work for IT personnel. We also have the right to request our information to be corrected, to be excluded. So there's a lot of new rights for the individuals, which will make certainly life much more interesting for companies, because the companies will need to have that in place. So not only you need to have your documents, let's say amended, privacy policy in terms of conditions, agreements with suppliers, agreements with clients, but you also need to change the whole culture of the company in terms of dealing with privacy. So privacy by design is something that certainly will have to be incorporated in the Brazilian mentality. In other words, when you think about a product, when you think about launching a services, you need to think about the privacy issues connected to that. So next chapter in Brazil will be very interesting for us privacy lawyers, I think. And I think I'll just, with respect to central bank, just a quick comment on that. So the central bank also enacted a new rule connected to database and to data, and in a way trying also to regulate services and companies which provide data to banks. So they will have to change their whole mentality in terms of the agreements they enter and how the central bank will need to approve. But obviously I'll leave this for our expert in privacy.
Okay.
Thanks.
So tell us a little more about the central bank resolution and how a bank gets ready to deal with it.
Okay. The resolution 4658 is a resolution that's more or less like the cybersecurity laws and regulations that we have here in the U.S. It gives you a set of rules rules that you have to follow to keep your data safe. And it's very broad, actually, and it's a good thing, because now in Brazil, I don't know if there was something before there. I don't remind that there was something so specific to cybersecurity. But now it's easier to go to your board and get resources for to get prepared for cybersecurity. So before, you had to prove that cybersecurity was something that was important, that you need to get the resource, that you need to be prepared for any kind of attack. Now it's the law, so you don't have to discuss anymore. It's set in stone. So you have to just to go there and say that I need this type of resource. Of course, you have to make your case. Nobody's going to give you money for nothing, but it's law, right? You have to do something. And it has some very interesting points, such as you need to you have to appoint someone as responsible for the cybersecurity program, exactly as we have the FFIC guidance here and the Part 500. There is a need for someone that's responsible for the program for the cybersecurity. And you have to do vulnerability assessment, penetration test. That's something that's also in the regulations here. So in a sense, it's more or less like Brazil is trying to adjust something, fill a blanket that is something that was not there before, now is there, something that you can create a baseline inside the company to address inside the kind of cybersecurity issues.
All right, thank you for introducing the resolution to us. Edgar, let's bring you in from São Paulo. The LGPD is going to be a big burden for companies in Brazil. Please talk a little bit about how a company will actually go about a compliance program for LGPD.
Okay. So good morning for everyone. Just to give you a perspective, we have a sunny day here, don't worry. But again, the LGPD is a very important milestone for us, because it brings a discipline to the market, as Marcela said. And it's very interesting. In the very beginning, when the law was approved, we had the legal department of the companies start leading the initial discussions, and they suddenly realized that probably would be much better a multidisciplinary approach other than just a legal approach, right? Just to give you an idea, since August, mid-August, it's almost 3 months, we were in about 75 meetings with clients here, just to give the perspective how is worrying the LGPD is worrying the companies here. But what we are seeing today is more people on the table to getting roles and responsibilities about LGPD. So I think the reaction has been very active. People are worrying about, the legal department is worrying about, the security guys are worrying about, the risk and compliance and IT guys are worrying about. So this is good. I think we're gonna put a perspective, a global perspective on privacy in Brazil. What we have seen in terms of industries here, we believe that probably the health industry in Brazil, particularly, we're going to suffer a little bit more. As Marcelo said, there were, a few drives for health companies in Brazil on privacy, but now it's very specific. Personal health information is considered to be sensitive, so they're going to have more to worry a little bit more than a personal PII, personal information. So we believe that the health industry is going to struggle a little bit more than the rest of the market, because they are really putting in privacy in the health perspective here. For sure, consumer-driven companies like retail, banks, insurance companies are still a second industry that has more challenges. And for sure, all the startups, fintechs, and digital banks, digital companies, let's say, analytics and data monetizing companies. Those are the market is hot on that particular subject. And the last thing that I want to point out at this moment is companies are struggling with the budget. What I'm saying is that the laws just came in August. They were analyzing and seeing that they're going to do something to understand what will be the gaps, and for doing that they're going to do all the data to understand where data is and the risks are. So budget for the next year is an important issue for companies to understand how big is going to be the budget for the compliance journey, because we have only about 1 year and something. It's going to be 1 year and 3 months, 1 year and something. So the last year budget won't consider anything for privacy, and the next year has to consider a lot. So what we are seeing here in the companies that they are struggling with how budgeting the next year for privacy.
Edgar, thank you. And Marcella, Edgar talked about the fact that there's not that much time to get ready. One of the other issues in Brazil is who is actually going to enforce the law, and whether we'll have an agency to enforce the law. Can you talk about that a little bit?
Of course, yeah. So the law.
Just 1 second. So the law was enacted, as we said, and this was in July. And when it was enacted, there was a big discussion in Brazil, because in that law we had an authority, a privacy authority being chosen, right? This was part of the law, and the authority is, let's say, this entity that will regulate all the rules, that will apply penalties. And in many places in the law, we see a mention to this privacy authority. However, because of political and constitutional reasons, so there was discussions about how this authority was going to be budgeted, and because of that, they decided to exclude, to veto. So the president vetoed all the rules connected to the authority. So right now, we have a law, we have rules and obligations, but we have no authority to enforce that. So this is a question mark and something that we are all looking for to be solved. So hopefully, with the new government, they will probably enact a new law and choose this authority. So the question mark is when this is going to happen and who will be elected, right? What kind of person? Is this someone that is going to act in defense of the consumers? Is this someone going to be more, corporate related? Is someone that is going to be active in terms of, making companies comply with the rules, but at the same time understanding the industries? And that's something that obviously we have no idea. There's some that have been mentioned as a potential authority, but we don't know really who that person would be. And in addition to that, what happens in Brazil is, so we have this new privacy law, but as I said, we still have rules which are connected to privacy that existed and continue to exist related to consumer and to the civil code and constitutional rights. So in addition to having a privacy authority, you potentially have also, the prosecutors continuing to act in terms of defense of privacy. So as we see now in Brazil, we have a very strong presence of the prosecutors, specifically in Brasilia. That will continue to happen potentially. And we also have consumer courts, which tend to be very proactive in terms of defending consumers. So this is also something that is a concern in Brazil. So even though we're going to have a new law, we don't have an authority. Even when we have the authority, there are some other players that tend to make trouble for privacy generally.
Do we know about privacy?
I have no idea. but obviously, he has this liberal agenda. So that's what he said in his campaign. So hopefully he will be more pro-business than just creating restrictions. Let's see.
Okay. We tried to get Mr. Bolsonaro on the panel today. That's his chair over there.
There is a missing place there.
Yeah, he was busy. Okay, so let's talk a little bit about those U.S. developments that we showed on the map before. Very quickly, the rule in the U.S. historically on privacy has been law and regulation has been very limited. Basically, there have only been two main rules, and I'm going to keep this high level. First, if you suffer a data breach in the U.S., it has been the law for many years that you have to tell the affected consumers, and you have to, in many cases, notify a regulator or more than one regulator. Regulators in the state where the breach happened, or where the consumers live, or a regulator for the business sector, like the banking regulator or a health regulator. Okay, so data breach notification has been the law in the U.S. for many years. Beyond that, on data privacy, we've really only had one rule, in a sense, which is that you can't break promises. Okay? We don't consider data privacy to be a fundamental right. We don't consider that the data subject, the consumer or the employee, has ownership rights over their data. We just take the approach that a company is supposed to give the consumer some limited information about what kind of data you're going to collect and how you're going to use it, and then you have to keep those promises. And if you break a promise to a consumer about how you will handle their data, that is considered an act of deception under our consumer protection laws. Okay? And that's about it. So it's a break no promises legal regime. So that's changing. And the cybersecurity world is changing too in the following main ways. We are, with the California law, we are moving now towards the idea that the individual has rights of ownership and control over their data, and that the company can only collect the data, can only use the data, can only transfer the data to a third party or to another country if the consumer is informed, has given consent in many cases, And if the consumer has rights to, as Marcelo said, will not be the rule in Brazil, it's now also the rule in California, you can go to the company that is holding your data and say, tell me what you have. Tell me where you keep it. I want you to correct the data. I want you to delete the data. This is now the rule in California, and we think will probably become the rule across the United States. I'll come back to that in a second. On cybersecurity, what we're seeing is, in addition to breach notification, it is now the law in many places in the US, including in New York, that your cybersecurity must be at a certain level of quality, or you're actually legally non-compliant if your cybersecurity is not good enough. It's not a matter of whether you've had a data breach, it's a matter of whether your security is just at a certain level or not. This is often referred to in laws in the US as a requirement of reasonable security. The GDPR has a requirement like this. They call it appropriate security. But the idea is that the law doesn't tell you exactly what you have to do. It just says it has to be reasonable, it has to be appropriate. And the idea is that the bar will keep going up. As the bad guys keep getting better, new threats emerge, new forms of cyber attack. You have to keep adjusting your systems to guard against that, or you're actually violating the law. New York, in the cybersecurity regulation, now requires that if you're a covered entity, a bank, an insurance company, you must do a regular risk assessment. You must implement a cybersecurity program that is risk-based and responds to the risk assessment. And that you must designate a person, a senior officer who's going to take responsibility. You have to submit an annual certification to the New York State government saying that your cybersecurity is compliant with the regulation. It is, for the most part, that principle of the bar is going to keep going up. Find out what your risks are and respond to them. But what we also see in US law is that more and more there are specific forms of cyber attack that are so well recognized that if you're not taking specific measures to protect against them, you're actually violating the law. So for example, if you're not encrypting your data, if you're a financial institution or a healthcare company, that is, for the most part now, a legal violation in the US if you're not encrypting. If you are a bank or a financial institution, if you're not using multi-factor authentication, this is, if I'm trying to log into my bank account, I can't just do a username and password. I also have to get a text message code, which is only good for 10 minutes, that sort of thing. That's a requirement now too here in New York. So what we're seeing is this kind of combination, reasonable security plus very specific individual requirements as they become more and more well recognized. The other main thing, just to come back to, I said this privacy notion of individual rights is expanding in the US. We are seeing for the first time a big conversation in the US Congress about whether we will now have a federal privacy law that would wipe the California law off the map. It would apply across the country, and it would basically bring GDPR to the United States. And all of a sudden, what's changed is we've had a lot of privacy scandals. We had Cambridge Analytica, we had the Equifax breach, and so this has become a bipartisan concern. It's not a Republican issue, it's not a Democratic issue. This is something the parties actually seem to agree on. And the other thing that has changed the conversation is the California law. The California law is nuts. It is crazy. It is so strict, it is so broad, that to use technical legal terminology, everybody is freaking out about the California law. And as a result, you actually have, you had a hearing in Congress a few weeks ago where Amazon, Apple, AT&T, Twitter, and a bunch of other companies went to the Congress and said, please regulate us. Please pass a federal privacy law that would take the place of the California law. And these are companies that have spent years and years fighting the idea of any kind of regulation of privacy, and now all of a sudden they're asking for it. That's how concerned they are about the California law. So the political dynamic is Democrats basically like to see more consumer protection, so they would like to see a federal law, and Republicans like to be responsive to business. So when the 5 biggest tech companies in America come to Congress and ask for a regulation, the Republicans say, sure, let's do that. Our Congress is obviously, it's a A lot of change going on, no promises here, but my one man's guess is that within a year we'll have a federal privacy law in the United States, and we may be having a very different conversation. So that's a little bit of U.S. perspective. Let's go back to some of our global challenges. So Jose, talk a little bit about how you deal with cross-border regulation. You're a Brazilian bank, but you have to live under regulation from New York. You have to live under regulation from Brazil. How do you make that work?
Well, it's not easy. Normally, we have been lucky so far because we don't have many conflicts. But now with these regulations that are from one country and affect the other country, it's becoming more and more difficult to manage that. Sometimes it's easy just to, it's as simple as just move your data from one provider to another, to encrypt, to change the record time retention, but sometimes it's not. So what we normally do, and this is my experience, not a recipe or anything, but what we normally do when the conflict is complex, that you don't know how to address, what we normally do is to bring someone with experience, like a consulting firm or an outside counsel, someone that has experience to deal with, and also to help you with a gap analysis. So to create an action plan, something that you can take to your board to get approved, and then implement. And of course, once implemented, it doesn't stop there, because the interpretation of the law sometimes is tricky. Sometimes something is this way one day and the other day someone challenged the law. So you have to be revisiting that implementation that you just finished, just to make sure that everything is as it should be.
Especially in Brazil.
Yeah.
Yeah, things change a lot.
Here too.
Here too? Okay.
Edgar, part of, please join in.
No, if I can make a point here on the 4658 resolution of Banco Central, when you think about cloud services, that's a big challenge for them. The financial institutions relate to, because the resolution regulates how you could use cloud services outside of Brazil. And this is a big issue, because sometimes you have a sense that you don't know really where the cloud is, and if there is an agreement from the Banco Central of Brazil with the company, with the Banco Central of that specific country where the cloud is. So it's a big challenge for financial institutions here in Brazil to understand what type of cloud service they have, where the cloud services are being executed, let's say, so where the data is stored. So those are the challenges for the resolution itself.
And just one point on to that, this also, the question of the cloud also affects the LGPD. So this is also, a company that is very concerned. So all the cloud providers are very concerned, thinking if they're going to continue to have services in Brazil, because nowadays, now that the companies may be held liable for any question related to the treatment of data, if you have a cloud provider that is not safe, that is not, protected enough, you may have issues too. And this is something that companies didn't think about it. So they had agreement with cloud providers, they didn't really do a due diligence, right? They didn't really think about who is that company? What kind of company is that? Do they have all the cybersecurity elements in place? So now this is something that is going to be changing in Brazil, not only because of the new resolution, the central bank, but because of the new privacy law.
But we are seeing also that the cloud providers are now becoming more and more concerned about security. So you see Amazon, Google, you see that all the certifications that they have is impressive. It's like they were born for that. Like they have, you choose one certification, 2007, 27001, it's there. You don't have to look for it, it's there. So what we are seeing is that the big cloud providers are spending a lot of money, put a lot of effort in getting ready for not only for the regulation in Brazil, but for everybody. Because here is also, you have to, here, you are responsible for the security of the data, even if you outsource. So
Yes.
it's not, you cannot tell Google or Amazon, oh, you lost my data, now go to explain that to my clients. It doesn't work like that. You are responsible for that. So you can later do something with Amazon, but it's your responsibility to your client to maintain the data safe. So the cloud provider, I don't know about the small ones because I really don't check this market so often, but the big ones, they are really investing in technology and cybersecurity. So I think that's a good trend. I think that's something that the other providers will do the same because they want to stay in the market. So if they do that, they're going to lose clients.
And here in the U.S., this idea that you have to do diligence on your own vendors, privacy and data security, you have to write terms into your contracts with the vendors on privacy and security, and then you have to maintain oversight once you've hired them and actually watch over privacy and security practices. This is a very strong theme in U.S. law and regulation now. The New York cybersecurity regulation requires that you do very extensive oversight, diligence oversight, monitoring of your vendors who are holding sensitive data, our financial data, personal data. And the New York regulation, just to give you an example of how hard this is, it has a staggered series of deadlines. Basically, DFS said, okay, you have to do the easy stuff by this date, then you can do the slightly harder stuff by a later date. And then way out, the last compliance deadline was for vendor oversight, and that's coming up next year. And why is that so hard? I was talking to a financial institution client recently who said, I have 25,000 vendors that I now have to bring under my cybersecurity program. 25,000. That is really hard. It just takes a lot of time and effort. And it takes, to some extent, a change in vendor culture. If you ask, Jose posed the question, what are the small vendors doing? We have a little insight into that because we see a lot of small vendors coming to our clients with agreements now where they say, hey, you client, you tell us, you certify to us that you are compliant with GDPR, with US privacy law, with whatever the privacy law is. And if you, client, won't certify to us, the vendor, that you are compliant, we'll fire you. It's, and just yesterday, I was having this conversation with a client. This is, it sounds, again, nuts, but this is the world that we're living in. Edgar, complying with all these laws, partly it's budget, partly it's specific things like encryption, but it's also corporate culture. And how do you change the culture of the company? Talk a little bit about that.
Well, that's a big challenge. Because when you think about privacy embedded in the culture, I'm not sure that it was part of the game at that point, right? So there's a big challenge. I think what is helping to change that is not only the law itself that must be complied with until 2020, February, but I think, as Marcelo said, the prosecutors in Brazil are playing a hard game. What I'm saying is that there are more than, that we know public, more than 20 notification for companies that have cyber incidents and data leakage in the marketplace. So this is helping to change the culture in a bad way. What I'm saying is that the board of directors are more and more worrying about that specific cybersecurity incidents or cybersecurity risks. So we believe that this is a good thing that is happening in some way, because this is giving awareness of how hard it is to deal with that cyber attacks and cyber incidents, and how it is difficult when you have the prosecutor on your door, knocking on your door and asking more and more details about the incident. So this is this is going to help to change a little bit the culture. And if you think about the LGBT itself, it's a matter of protect individual information, but when you see on the corporate organization perspective, we are talking about consumer data, employees data, short-term employees data, third-party employees data, clients and providers. And most of the companies still have what we call here in Brazil short-term employees or third-party employees. They still have not only the HR system, they have that on the procurement, Excel, they control the third-party information on an Excel spreadsheet on the procurement department. So there is a big change on how you build your process. The concept of privacy by design and privacy by default is not embedded on the companies at all at this moment.
All right, thank you, Edgar. So we're going to go down into the weeds a little bit on LGPD for just a couple of minutes. LGPD and GDPR both have this basic principle. You can't do anything with data unless there's a specific basis for it in the law. You cannot collect it, cannot use it, cannot sell it, cannot transfer it, unless you can point to a specific rule in the law that allows you to do that. And one of the main rules is something called legitimate interest. If it's in the legitimate interest of the company, then you're good. Marcelo, what does that mean, and how does a company work with it?
Sure, and just before going there, just to add some points to what José Carlos was saying, one thing which is important to note about Brazil, so we don't have notification obligations we didn't have notification obligations in the laws, but these prosecutors in Brasilia, they created this obligation according to a specific portaria that they created. So they launched this task force, this privacy task force, which requires companies that have data breach to notify. So this is not in the law. Now, with the new law, yes, there is an obligation, which also is going to change how companies do business, because they really need to be concerned. There is a legal obligation now to notify if there is any data leak, any breach, and you have to not only explain which data was leaked, you also have to explain what were the measures implemented by the company in terms of protecting data, which certainly will help in terms of reducing penalties, etc. So this is something that is going to change a lot the culture in Brazil. I think that the prosecutors have already created this, let's say, awareness, because they've been very active, this prosecutor team in Brasilia, but now with a legal obligation, I think this is also something that will make companies be more interested in complying with the law. So talking about this legitimate interest. So as I said, in Brazil, we have this principle of express consent. So it doesn't, for like privacy policy or terms and conditions, you not only need to say, if you enter the site, you have agree. You need to have, I agree with the terms. I agree with you sharing my data. I agree with you keeping my data for that purpose. So this is something that is, let's say, part of Brazilian culture, privacy, differently from US, right? The idea here in Brazil is that the data belongs to the consumers, right? So that's why you need to have their consent when you use their data. So the new law changed that a little bit. So they created different, let's say, justifications for you to treat data. And one of them was the legitimate interest, which some companies thought would be, the solution to all the issues. They would say, okay, I have a legitimate interest because that person is my client, because that person is, my provider, so I have to keep the information. But that's not really why, the legitimate interest was included in the law. And that's not how this legitimate interest is being enforced in the European Community, in the GDPR. This is also, by the way, this is also included in the GDPR, so we actually, like I said, copy that from the GDPR, and over there, this has been applied in very specific situations, only if you can show that there is benefit to the user, to the data user, and most often in connection with fraud. So if there is a question of, avoiding fraud, it may be reasonable for you to use legitimate interest as a defense or as a, let's say, a justification for you to treat the data. But it's not something that we can use all the time. So one of the, let's say, big challenges that we're going to have with the new law in Brazil is actually to try to characterize the treatments that the companies do, not only using consent, but the other potential uses we have in the law, and how to really accommodate that to what you do. So in terms of how we have to do that, it's not only reviewing documents and checking privacy policies, but we need really to have a team of people from the companies, from IT, from human resources, marketing, legal, compliance, thinking about that, discussing the process. There is a big change to happen in Brazil. Certainly the time we have, this now 1 year and 2 months, it's not going to be enough. So a lot of companies, I'm sure, will comply later in the game. So the sooner the companies start, the better.
Let's talk a little bit about data security now. One of the things I know keeps information security people awake at night is business email compromise. What is business email compromise?
Business email compromise is a scam that, according to the FBI, until now they think that the loss amounts to like $3.7 billion in money lost already. And it's a scam where an attacker, get the credentials, takes control over email accounts of an executive or a person with authority to approve money transfers. And this attacker waits until the right time to send an email with the instructions to make a payment. That right time may be the company is buying another company, the company is paying invoices for a certain project. So at that right time, because the attacker is undetected, just reading the emails. When the attacker sees the right time, he sends an email to the company, changing some parameters in the fund transfer, such as address or where the account, the destination account. And then, of course, there is some social engineering there, because the attacker normally calls the person in charge of making the payment to say, this is urgent, you cannot tell anyone because it's confidential, we're gonna lose the deal because of that. So the person that's under pressure, the person sends the money, and the owner of the account that was hacked only knows about that when the person comes back. Normally that happens when the CEO goes on vacation, or the person is doing something abroad that doesn't have contact. So it's a scam that's unfortunately very common here. And what we can do to prevent that from happening is train your employees, tell them that if something doesn't look right, probably it isn't. So, and banks are normally accustomed to that, to call the person that's approving. So it's not new for us, but for companies, like the regular companies, they normally they normally trust emails, and you never rely on emails for transferring money. So one solution for that is make sure that the employees that have authority to send money, they call the person that approved the transfer and confirm that the money is supposed to be transferred. So unfortunately, this is something that is very difficult to prevent. It's something that is, gives a lot of, causes a lot of loss for all companies, for many companies, and unfortunately, it's going to continue happening. I don't think it's going to stop soon.
And Edgar, another thing that is difficult to prevent is ransomware. Can you talk about that a little bit?
Yeah, and ransomware is a headache, right? It's amazing because it's a business, right? Ransomware start for or in a more strong way on with WannaCry, and from a year and a half or almost 2 years, is being one of the most profitable scheme for attacking specific clients or specific business. We have seen in Brazil many law firms being attacked by ransomware, and that's very, very common now, and which is not good because, as you know, ransomware, what happens is a malicious code, let's say, that is embedded on your IT infrastructure in some way, on your server, on your laptop, on your mobile, and it takes control. So the attacker takes control of everything. And what they ask for to give back to you the control is money, crypto moeda or bitcoins, cryptocurrency or bitcoins, and it's really bad because there is an impact on the operational side, financial, and everything. So ransomware has been a headache. If you take now in Brazil they are attacking doctors, physicians, medical clinic, hospitals, because they have sensitive information, and they are getting money on that as well. So is a headache, and companies are most of the companies are being more aware of that, so they are putting more robust procedures on the cybersecurity defense, working with threat intelligence or something like this. But if you think in a big company, that's easy. When you take a medium and small company, or a doctor or a physician, or a medium-sized medical clinic, they don't have really strong and robust, and they won't get it. So they have to worry about for sure.
Ransomware is a huge problem in the U.S. as well, and the FBI, it is not their official policy, but if you ask the FBI on the side, they will usually tell you just pay the ransom. Because it's the choice between having your network up and running and having your network be unavailable. And especially if you're a healthcare company, if you're a hospital, imagine what it's like to not have working computers. That's what a ransomware attack is. But Marcelo, we heard from Jose and Edgar about the technical attacks. How does the law look at this kind of cybersecurity problem? And how does the insurance company look at it?
Well,
Oh, sorry. So it's funny. We had a client that had a cyber attack, and he mentioned to us that he didn't have an insurance, but he did look for an insurance right after that. So that certainly didn't help. So insurance companies are very concerned with that. We do have in Brazil insurance policies for cyber attack. And of course, it's something that is highly recommended now in Brazil. We did have a lot of data breach, as you know. Some of them caused because of some leakage, but some of them caused from hackers that were active and for any reason decided to attack one company or the other. So this is something that nowadays I believe companies are including in their budget as well. It's a cybersecurity insurance. It's part of what they have to do. In terms of the law, according to the new law, you do need to notify if you have any data breach. So if you have an attack, if you have someone that is, let's say, potentially going to leak your data or has already captured your data, in principle, you will have to notify the authorities, right? I mean, and I'm talking about the situation where we are in, February 2020. So in principle, we have to notify because it could be considered a data breach. And obviously, we understand that at some point you need to keep things confidential. You need actually to first of all understand what is that is being leaking, what is the type of data that may be somehow problematic, or what kind of issues you may face before you go into the authorities. And we had another event before, Jeremy and I, and Jeremy was talking about this, friendly officer that you may have in the US. You may go and contact and discuss any issues you have, and they may be very helpful, which I understand they are. We don't have that in Brazil, so we don't have any friendly officers. So you really need to have good companies assisting you in terms of understanding exactly the extent of the issue. Consulting companies like PwC, for instance, have that type of capability and have worked in cases like that, and it's the way to go, I believe.
The FBI is actually quite supportive of business in the U.S. on these issues, and we would call the FBI or the Secret Service in the event of a data breach. We're just about at time. I want to close with a news headline. This is one of the first enforcement actions that's been taken under the GDPR, and I think it shows maybe a little bit of what you have to look forward to under LGPD. It happened in Portugal, and the Portuguese privacy regulator just issued a fine against a hospital. This is a brand new news event. 400,000 euros was the fine. And here's what the hospital did wrong. Here's the violation. The hospital, the regulator came in and did a privacy inspection of the hospital, and that's another thing companies have to look forward to now. And what they saw was that the system at the hospital was set up so that every doctor and every social worker could see all the data of every patient. Didn't matter if you were actually treating the patient, didn't matter if the patient was, if you're a doctor, maybe if you're a cancer doctor and it's an orthopedic patient, you could still see their data. That was the violation. There was no data breach. There was no misuse of the data. There was no harm to the patients. It was just the fact that access to the data was not limited properly. And based on that, the hospital has to pay 400,000 euros, which is a lot of money. And the potential fines under GDPR could be actually much higher. It goes up to 20 million euros at the high end, or 4% of global revenue. It's 2% in Brazil, is the maximum.
Yes, yeah, and actually also temporary suspension of activity and suspension of activities. So that's even worse.
So I think it just goes to show that the regulators are going to take this stuff very seriously. And you don't need to have an incident to have a problem under the law. Just having your systems not organized properly, that in itself can be the violation and can be the trigger for these regulatory fines and penalties. Then I don't know if we have time for a question or two. Should we do? Okay, so we can open it up if there are questions from the floor.
Hi, Eric Bergen, CyberS. Question, in Brazil...
Do you mind using the mic just so it'll help Edgar to hear? Thank you.
Sorry, I didn't read the regulation in Brazil before coming to this meeting, but the question is there any direct relation between the LGPD, that's right, and the central bank regs, and the CVM, or Novo Mercado, or listing requirements? I.e., when the CFO signs the annual report, says everything is okay, audit-wise and cyber-wise. Like in Dodd-Frank, you do have that. Do they have that in Brazil or not? Or will they have that? And you're the hook by saying, I'm okay.
Well, so the question is, will they have a regulation of that, or will they make you liable for that?
Well, basically liable. Will the CVM make you liable as a listed company?
Yeah. I mean, and so the LGPD already makes the companies liable, right? If you are the one controlling data, so if you are the one that decides what to do with the data, you're a controller, and you're liable for that. They will have, this new law talks about a privacy officer, some sort of DPO like they have in GDPR. In Brazil it's called encarregado. And that person will have a lot of liabilities too, and that person will have to respond to the authority. So that person is a connection between the company and the authority, and they may have potential liabilities too. So certainly whoever signs on you're okay with cybersecurity, you're okay with, will have a bigger weight on their shoulders now, and there is a connection. I mean, I would say that this, cybersecurity law in for the financial institutions, the LGPD, and the new regulations everywhere, they're all connected. The idea here is whatever you do in terms of data, you need to be protected, right? You need to use it for that purpose. So I guess the hospital was fine because they were using data for a purpose that the patient didn't know, right? So if you are a patient, you imagine that your data will be disclosed to your doctor and whoever is treating you, but not to, to someone that has nothing to do with your case. And this is exactly the idea behind all those rules, new rules that we're seeing here.
Just to give you the U.S. perspective on that, the New York regulation requires the certification by a senior officer or by the board of the company that you're in compliance with the reg. DFS has published a form that you're supposed to complete. It's one page, one sentence. It says, we comply, sign here. Okay? And we have clients coming to us and saying, well, okay, can I be compliant with an explanation? Can I sign the form and then staple something to it that sort of lists all the issues? And DFS has said, no, you're either compliant or you're not. And if you don't sign, and so then the senior officer says, wait, I can't sign that form. We have problems. We're working on it. But, if I can be compliant with an explanation, I'm good. But otherwise, I'm not going to sign my name to that thing. So here's what DFS says about that. If you don't send in the form, we put you on a list. We take that as an indication that you have a compliance problem, and you go to the sort of the top of the list for inspection. This idea of the signature and putting the personal responsibility on the senior officer is very important to the U.S. approach. And I think back to corporate culture, it has a wake-up effect inside the company. When we work with clients on their DFS compliance program, the first meeting we bring in and say, okay, who's going to sign this thing? Volunteers, who wants to sign this thing? And then you find that person at the beginning of the process and you say, okay, this is you're responsible for this. And they then have to kind of watch the entire risk assessment process, the evolution of the cybersecurity program. They have to personally own it, and it does change the culture.
Yeah, and in Brazil, it's very uncertain still who will be that privacy officer. So we don't have that in Brazil. There are few cases. I have some clients that have a privacy department, that they have privacy officers, but they're an exception. So a lot of companies will have to think about who is going to assume that responsibility, which is going to be a challenge as well. I don't know who will be, who wants to sign that.
Jose, do you want to sign that?
No, I don't. And according to that central bank resolution, there is also a need to appoint someone that's responsible for the cybersecurity program. So it's more or less like the 500 here. Someone has to be responsible for anything that may happen. So it's have to have large shoulders.
Yes, exactly.
Jeremy, if I can point one, I just want to add something on that on that question specifically. SEC companies in Brazil are following the SEC company cybersecurity disclosure that was a statement by the SEC on February this year. The CVM is following a little bit the idea of being more tough in terms of disclosure for cybersecurity risks. And the Banco Central resolution is also saying that all the cybersecurity policies, incident response policies, and the cloud security that is under the resolution has to be approved by board of directors and must be a formal approval as well. So I think everything is closing to the same point, that they are putting responsibilities for the management, for sure, and they want to be sure that they are secure for the society. So the CVM is following, all the other regulators like SUSEP is also following as well in the short term. So we believe that in Brazil, always the regulator comes after. So they're coming. Right?
And this is a board issue too. We've talked a lot about management responsibility. Part 500, which is the New York Cybersecurity regulation, requires board engagement on these issues as well. The board has to actually have visibility into the cybersecurity program, has to be briefed regularly, and this is very important. The board actually has to be involved in the process of making the decisions about what risks to accept. And Jose will confirm this, I'm sure. Cybersecurity is all about choosing where your priorities are going to be. There are too many problems to solve them all at the same time. You're always setting priorities, making lists, saying we'll do this today, we'll do this tomorrow, we'll get to that problem in 6 months. That problem over there, maybe we'll just leave that alone because we think the risk is low and it doesn't justify an investment in security measures. So those are the choices that people like Jose have to make every day. Under Part 500, New York says the board has to have a conversation about that. The board has to be part of those decisions. So you can't have your information security officer just come into the boardroom and say, we're good, locked and loaded. That's actually not a legally compliant approach. It now has to be a more detailed conversation with the board under the New York regulation. So the board...
Very happy with that. You have responsibility.
Many shoulders. We have time for another question, maybe.
Yes. Thank you. Thiago from César Sierra. We have actually 2 questions. Maybe it's better to Marcela, but you can try to say how it was here in the US, Jeremy. The first one is why we need so much time to apply the new regulations, because as we saw, we have the civil code, we have 1 year to be applied, and the civil procedure code that are many rules and are much more complicated, and we need just 1 year to be applied. And the second question is, how do you think that the prosecutor can work in this process, because the new regulations, it doesn't have any rule that has criminal sanctions, and how this, do you think that there are another rules that can be applied, like criminal rules?
Yeah, so first of all, talking about the term, I mean, I don't think it's a too long period of time, because I think that for the companies to be in conformity, they will take even more time than that. First of all, there's a question of budget. So a lot of companies that we've been talking about, so this, past 3 months, we talked a lot with a lot of companies. Most of them didn't have a budget for that, right? And I'm talking about companies which are not in the pharma business, they're not in the internet, they're just regular companies which do have information, which do have data, and didn't really think much about that, right? So those types of companies, we need time. We need time to understand what they have to do. So just to give you an example, I mean, to be in conformity, first of all, you need to have an understanding of what are the rules applied to your company, right? So some companies have regulatory restrictions, not only the LGPD, but they have other rules applied to them. So like financial institutions, insurance companies, pharma companies, they have specific rules. So you need to understand that. You need to understand the law, the new law. So this is one step, which I think takes a while for companies to understand. You need to create a group within the company, with senior management, with people that decide. And I know that this, making a team also takes time, because there's a lot of discussions about who wants to be responsible for that. So this is also something that takes some time. After the team is created, the team needs to meet and discuss what they're gonna do, what they're gonna implement. And on top of that, there is a question of data. Where is the data? In most companies, they don't know. They don't know. They really don't know in Brazil. They we lost.
Eric, if you can hear us, we don't seem to have São Paulo on screen anymore. Should we try to get them back? Thanks.
But anyway, so one of the big issues is what is the data? They don't know, and they have to track that data. So they have to actually, and this takes some time to do, to tracking of data, to understand the process, when the data starts to be part of the company, who keeps that? You know that some parts of data are kept by, human resources, parts are kept by the IT team. They don't know. When I've talked to company, and I've had that experience, so I discussed this with companies, and it's funny how you start the meeting, discussing, explaining how things work, and they're like, no, we don't have any personal data. No, we don't do that. And then they start thinking about, oh, this is personal data. Oh, we may have that. In fact, we collect that right away. When a person calls here, we already collect data. So it's a lot of change in the culture. So I don't think it's a long period of time. For Brazilians, as you know, we tend to do things at the last moment. It's true. I mean, it's a Brazilian trait, I would say. So hopefully this is not going to happen in this case, because we'll need time. Companies need time to do what they have to.
Yeah, on that, if I could jump in for 1 second. GDPR, companies had 2-3 years to work on their compliance programs. There was a survey published recently by one of the major consulting firms where companies were asked at May 25th, 2018, which was the effective date, are you compliant? Only 40% self-reported that they were compliant. And that was after years of effort. That's 40% say they're compliant, 60% admitting they're non-compliant, 40% probably lying. Because it's really hard. It's really hard.
It's very difficult. It's very hard, and it's a change in the culture. Like I have a client, and for them, this company, they collect information, personal information, all the time, and they use that for their own processes. They use, to sell products. They use to understand what the consumer wants. So when I told them, look, you're gonna have to change the process. You're gonna have to stop doing that. How can I do that? They survive with that information. So it's a challenge, and like Jeremy said, we know that in the European community they're still working on that. That they will for a long time, I think.
There was a question about criminal as well.
Yes. All right. So the second question about criminal prosecution. So first of all, the prosecutors in Brasilia, the group that I mentioned, the task force that deals with privacy, they're still alive, and they will continue, of course, to work. I think this is a type of matter that it's an interesting matter for the authorities. They like privacy. So as bad news for the companies, because I don't see them just quitting that now that they have the knowledge. Obviously, how this authority will be chosen and how this authority will act may cause a change in the pattern. I believe that if you have a very strong authority, if you have an authority that is active, maybe they will concentrate all this work connected to privacy. But as you know, in Brazil, there's a lot of discussions. Authorities like to appear. There's media involved, and so I don't think that is going to stop. Basically, maybe it will decrease because they will have now a new authority dealing with that, but it is not going to stop. And criminal prosecution does exist depending on the crime. So there are some crimes now just connected to the digital world, connected to privacy, which may cause criminal prosecution.
Yeah, no, I just want to add something on that. I was dropped a little bit for 2 minutes, but I'm back. So I think there's something that we have to have in mind, that is the reputational risk. And this is really important, because if the authority is going to be hard or not, it is something that we have to take into consideration. But a reputational risk is really an important issue. As you mentioned, the Portugal hospital that had a problem there. Me as a consumer, should I go to that hospital again or not? How is going to be the impact on that hospital in terms of rent? So this is important, and we have to take that in consideration. And one issue that I think is going to be the new normal for companies at all is how to work with elimination or deletion or elimination of data. Because nobody in Brazil, I don't know in the US, but no companies in Brazil have a policy for deletion for destroyed data. They just backup, they just buy more storage, and the law is very restrictive on you have to collect information, you have to use for that purpose, and you have to eliminate that data. So there's going to be a new normal for companies that probably is going to go through elimination of data, managing the consents, and data portability, as Marcela said, how to deal with the incident of privacy, because maybe they have something on incident of cybersecurity, but they don't have for privacy. How they're gonna retention data? How they're gonna review the data governance? So this new normal is gonna change a little bit. It's gonna be a challenge independently of the law itself, right?
Jose, can you talk a little bit about getting rid of data? How important is that? How do you manage that challenge?
Not easy at all, because so far we, as financial institutions, we keep records because we need to keep records for audit trail, for keep to provide statements to the client. So when you have a law that requires you to delete that, you have to go through all your systems to see all the dependencies where the record is, and if you can eliminate that, or if you're gonna need to keep that record for any other reason, because it's not like a black and white. You cannot say just eliminate. It's something you can keep if you this and that. If you don't have that, then you have to delete. So it's very complicated, and for a bank that has thousands of systems, it's a major job, because it's very complicated, because nobody really knows exactly how the data goes from one system to the other. So it's very complicated. There is a task force involved only for this type of adjustments in the system.
And to add something related to that, so in terms of deleting data in Brazil, you cannot follow the rule completely and deleting, right? Because you do have, sometimes you need to keep information because of tax reasons, labor reasons, financial reasons. I mean, there are many laws in Brazil that require you to keep information for 5 years. And then there may be investigation, so you need to keep the information to provide to the authorities. But what we believe is going to happen is that if you receive a request for deleting your information, what you have to do, if you are not able to completely erase that information from the database, is to stop using that information for marketing reasons or whatever reasons you may have, right? So you can keep that. That's what my understanding. You may be able to keep it with a justification that you have a law that requires you to do that, but you cannot use that anymore.
Okay, with that, we are really just about at time now, so a couple of things before we conclude. It's almost Christmas. Your children will enjoy receiving the Privacy Law Answer Book, written by Deborah Boysen-Hunton, available from the Practicing Law Institute. Kidding aside, we're very proud of the book. We think it's a good resource. I'll challenge the panel a little bit as we wrap up to give us all one word, something to worry about for 2019. And I'll start. My word is California. Is that one word? What's going to keep you awake at night?
Third-party service providers, cybersecurity requirements for them.
The new authority.
Edgar, one word.
Clients. Most of the time.
That's a good word to end